Assalamualaikum warahmatullahi wabarakatuh. This is second part for our recorded lecture for the topic product liability. So in the first lecture, we discussed about the definition and we compare with the drawbacks, okay, or the limitations under contract law, okay, under negligence law, tort law, basically, and then which leads to the introduction of strict liability for defective product, and we have it under CPA, Consumer Protection Act 1999. And we also covered about who could be sued, okay, by the plaintiff under CPA. Basically, it covers the three main person, okay, or uh, it's not really individual, the person, all right? I think this is, okay, here, okay, persons lah, that's the word used. So now you want to move to the meaning of the word product. Okay, what's the meaning of the word product here? You can refer to the actual provision. This is only the summary, okay, for the purpose of the lecture. So section 66 of CPA, it defines product as following, okay? It defines as any goods, and subject to subsection 2 includes a product which is comprised in another product. So it's product within a product, whether by virtue of being a component part or raw material or otherwise. So it includes component, it includes raw material, it includes product as a whole, but it is subjected to exclusion here, okay? So liability under part 10, okay, will not attach to, this is under section 68, section 5 as well, okay, here. A person in respect of any defects in agricultural produce, if the only supply of the agricultural produce by the person to another person was at time when the agricultural produce had not undergone any industrial process. So meaning that here, this defective product, it doesn't cover agricultural produce, provided this produce, it doesn't undergo industrial process. For example, it doesn't go canning or whatever. It is still the raw, the raw material of agricultural produce, the fresh one. So it's not, it doesn't fall under definition of product or defective product here. Okay, now we want to focus on the most important part, basic elements to prove liability under CPA. So there are three elements or requirements here. Okay, first, plaintiff or claimant must be able to prove damage or injury that he suffered. And then the second one must prove the defects in the product. And the third one, the linkage, causation. The three elements altogether. So for the first element, it is covered or it is incorporated in section 66. It defines damage to mean death or personal injury or any loss or damage to any property, including land. But there's also exclusion. It comes with it. Okay, exclusion here under section 69. So it excludes the defective product itself. So it's not part of the damage. It's not considered as damage or the injury. Okay. And it excludes product comprises in the defective product, whatever product in the defective product. And it excludes commercial property. So it doesn't come under this CPA, basically. That one is covered under the statute. Okay, the second element just now is about the first element, okay, the product. Okay, now the defect. The first element was the injury, okay, the damage. So the second element is defects in the product. Now the zoom or the highlight is on the defect. What's the meaning of the word defect here? The product must be proved to be defective before liability can be imposed on the defendant. After all, this is something which is strict liability, okay? So as far as the defect is concerned, we can divide, okay, or this is subdivision, okay? We can further divide into three types, three categories. It's either manufacturing defects, it's either design defect, it's either marketing defect. Is it possible to have combination? Yes, it's possible, but at least must prove either one. But if you can prove more than one, then it's a strong case altogether. Okay, we go one by one. Okay, what's the meaning of manufacturing defects? Okay, manufacturing defects, the word is self-explanatory. Okay, a defect which occurs, which happens during the process of production. Okay, what's the reason? Due to miscarriage of the process, okay, of construction or assembly, the way it is being assembled, or even its container, okay, or unintended ingredient, okay, contaminated, for example, okay, or defective raw materials, okay. So it could be all the reasons, okay, may be responsible for the damage. Like what happened in Donahue and Stevenson. Remember the snail in the bottle? Snail shouldn't be in the bottle of ginger beer. So that one is unintended ingredient. So it's considered as manufacturing defect. It happened during manufacturing process. The second types of defect is design defect. What is the meaning of design defect here? It refers to defects in a whole run of product here. Okay, for example, the danger may stem, may come from the choice of inappropriate materials, from the product formula ingredients or specification, or failure to incorporate sufficient safety measures. So normally it is relevant, it is found in high-tech products, such as chemical, because it has to be very specific content. It must use certain specific ingredients, specific content, the correct mixture, correct proportion, right? Drug and medicine. So we have the case of Abu Zaid and Madake. We're going to discuss this case after this, reported in 201. The third one, the third types of defect in the product here is marketing defect. What's the meaning of marketing defect? For example, the product doesn't contain manufacturing defect, it doesn't have design defect, but it might have marketing defects. So what's the meaning of marketing defects? This is a product which is properly designed, properly manufactured, but eventually it became unsafe due to insufficient warning labels or direction for use. So this is also considered as a defect. It should contain sufficient, reasonable, warning label, or even how to use it. This is what happened in the case of Wackfall Company Limited and BDH Chemicals. We're going to discuss the case after this. Okay, actually the definition of defects, you can find it under section 6.7, subsection 1, this is the part of the provision here. Subject to subsection 2 and 3, there is a defect in the product for the purposes of this part. If the safety of the product is not such as a person is generally entitled to aspect. So it combines all the three categories of defect just now. Okay. So, and what's the basis of this? So the definition of defect is based on the concept of safety. The moment it's not safe, then it is considered as defective. It contains defect. Having said so, part 10 here, it has no application to safe but shoddy product, very low quality, but still it is safe. Then you cannot really apply part 10 of CPA. Because why? It doesn't satisfy the requirement of defects, because defect means not safe. Here it's safe, but it's just shoddy, not properly done. Where not carefully manufactured, but still it is safe. So you choose to buy, then you have no remedy afterwards under this CPA. So, and then essentially, as a whole, part 10 here, it adopts our part 10 CPA, 1999, it adopts the consumer expectation test in determining defective product. So what's the meaning of consumer expectation test here? What a reasonable person, reasonable consumer, is generally entitled to expect, because when we buy something, we have certain expectation. Product must be safe. It must meet certain, must be up to certain standard. And if you refer to section 6.7, section 2, it contains or it lays down guidelines and states that all relevant circumstances shall be taken into account. This is how the court will decide whether to see, is it considered as defective or not here. Basically all the requirements here, actually they are all, all relevant for the three categories of defect just now. The first one, the manner in which and purposes for which the product has been marketed. That one under the third category just now. Or even the get up of the product. Get up is the appearance of the product. The use of, or the way, the wrapper even, relates to that. The use of any mark in relation to the product, the instructions for warnings with respect to doing or refraining from doing anything with or in relation to the product, what might be reasonably expected to be done in relation to the product, the time when the product was supplied by its producer to another. So all this will be considered by the court in order to determine is the product defective or not. Okay, let's go to cases. We haven't come to the cases. Cases are all interesting under this topic. The first case, this is all common law case. Okay, the first case, A and others, a National Blood Authority and others reported in 2002. It relates to, it's pertaining to contaminated blood. Okay, it's possible when somebody donate his blood, okay, the blood could be contaminated. Okay, so contaminated blood was held to be defective because why? The judge was satisfied that the public at large, including us here as a whole, was entitled to expect that the blood transfused to them, okay, when we receive blood, okay, would be free from infection. That's the expectation from the public. So the moment it is contaminated, then it is considered as defective product. And in the case of Abu Zaid and Mothercare, reported in 2000, year 2000, sorry, the Court of Appeal held that pushchair, okay, pushchair is stroller, okay, push, in UK they use the term pushchair, okay, the pushchair's cover, okay, was defective because why? The consumer is entitled to expect that the product to be safely designed. The design has to be safe. The moment it is not really safe and it's being used, then it is something which is defective. Okay, let's have a look what happened in this Abu Zaid case here. Abu Zaid and Mothercare, meaning that here, the mother, okay, was suing Mothercare. Mothercare is very established company, okay, in UK. Even we have outlets of Mothercare in Malaysia. Okay, so plaintiff, he was 12 years old. I mean, still young. He was helping his mother to attach a Cosito's fleece lined sleeping bag, like in the picture, okay? Because in UK, most of the time it's very cold, especially in the winter. So when they use this pushchair, it has to come together with this sleeping bag, okay, to keep the babies warm, basically. Okay, fleece lined sleeping bag to his younger brother's pushchair. So he was actually trying to help his mother, and the product was intended to be attached to pushchair by two elasticated straps. Okay, I'll show you the picture after this, which were to be passed around the back of the pushchair. I mean, round, okay, here, from each side of it and joined by a metal buckle, not any buckle, not plastic buckle, here, metal buckle attached to one of the straps. So it's very flexible. I mean, you can just pull it, okay, to fasten the buckle, metal buckle here. That's the picture of the buckle, basically. This example, I just Googled the picture. Okay, Clement was attempting, I mean the boy, the 12-year-old boy, was attempting to join the straps by attaching the buckle when one of the elastic straps, okay, because it's elastic. So, I mean, if you, I mean, the moment it gets out from your hand, then it might go anywhere, okay, here. So slip from his grasp, okay, following which the thought elastic flew back and the buckle hit him in his left eye. And here it flew to the eye, which was at the level of the buckle because he's a small, I mean, he was in the position to attach, to fasten the buckle, okay? So the retina of the eye was partly detached, leaving the claimant with no central vision in that eye. So he lost the vision for that eye, basically. So that's why the mother was suing Mothercare, and it was actually found to be defective. Okay, it has to be designed in a more safe manner. Okay. Another interesting case. Okay, you can see the signage. Okay, I mean, very popular, very famous worldwide, even in Malaysia. So the case name is Bogle. Even the name is also unique. Bogle and others. So they were suing McDonald's Restaurant Limited in year 2002. What happened? The spillage of hot drinks served by the defendant, by McDonald's staff, had caused serious injuries to the claimant. In the year, the hot drinks actually injured the claimant, the user, the consumer. Okay, they argued that the hot drinks was defective, okay, because it was too hot and served in the cups with lids which came off easily. So that's their argument in the court. They say, well, this is a defective product. Okay, the drink is too hot, even though they order hot drinks, and the drink is too hot, and then the lids, okay, the upper part, okay, here, like in the black color one, right, the cover, so came off easily, okay. But the court held that, okay, the safety of the hot drink served by the defendant was such as person generally entitled to expect, since temperature at which the drink was served was acceptable. I mean, it's not boiling water when the defendant bought it, okay. I mean, it is safe to drink. And given that customer will not have wanted to drink at lower temperature, because if they serve it, lower temperature, customer will also complain. Okay, it's not hot drink. They are buying for hot drink. And the design of the cups was also reasonable because the lids had to be easily removable for customers' easy use, because if it's too tight, also it will, it will pose, okay, it will be the high risk, okay, to the customer, okay, to open it up, okay, to remove the lids, okay, because they want to drink the hot drink here. So overall, okay, finding by the court here, it was not defective. Okay, another interesting case. This is with regards to family planning. The case name is Richardson and LRC Products Limited, reported in year 2000. What's the product involved here is the condom. Okay, the condom used by the claimant's husband, okay, it burst during the intercourse, right? And because of that, it caused pregnancy, because condom is not supposed to be burst, okay? Otherwise, it doesn't serve the purpose. But the court held that the condom was not defective. Why? Okay, the reason was that no one has ever supposed that any methods of contraception will be 100% effective, because there's no 100% effective family planning. It could be 99%, okay, 98%, but no 100%. Okay, so especially in relation to condom here, okay, the product is required to be, to a degree at least, to be in the jargon user friendly. The user, okay, cannot expect the condom not to burst. Something which is possible to burst, but then it's the way you use it basically. Okay, you can read the case later. Okay, another case here, also interesting case, Tesco Stores Limited and another and Poland. This is a good case, I think, because it's the mother who sold Tesco stores here. So a 14-month-old child, okay, had been seriously injured when he had swallowed, okay, some dishwasher powder. It was sold in a bottle which bore a child-resistant closure. The bottle is supposed to be tight. It is child-resistant closure. It's not easy for a child to really open, okay, the bottle. Okay? And the mother sued the Tesco. Why? The mother alleged that the bottle was defectively designed, since it was easily opened by her child. I said, no, it's not really child resistant, the closure here, okay, because why? My child could open it and it caused injury to the child. But this is the observation by the court. Okay, although the bottle's squeeze and turn cap did not meet the British standard, because the British standard is higher, okay, for child-resistant closure, but on average, okay, it was not defective based on consumer expectation test. It's tighter compared to normal bottle actually. Okay? And the court gave reason here. Members of the public were unlikely to have any idea of what safety standard the product they were, okay, buying. But so long they know, oh, it's a slightly tight compared to the not child resistant ones. Okay, so accordingly, they will be entitled to expect only that a child resistant closure will be more difficult to open than ordinary screw top. So that bottle actually met this expectation. That's why the mother lost the case. Okay, the third element. So we have discussed the first element, okay, there must be damage or injury, and then the product must be proved to be defective, okay, we discussed thoroughly, we discussed the cases as well. Now the third element is causation, the linkage, okay. The plaintiff must establish a causal link between his injury and the defect. Causal link between the first element and the second element, all right. But in some exceptional situations, it's very difficult to prove, okay, especially in cases involving health effects, okay, adverse health effects. For example, drug or cigarette or even ELF radiation. Because why? Because injury pertaining to health, it can be cumulative effect. It's not the only reason, okay, why you suffer those injury, why you suffer those disease. Okay, cumulative effect of prolonged or undiagnosed exposure, and it can take years to develop. So how do you prove causation? How do you prove, oh, I took this pill and after 10 years, I suffer this injury? How do you prove that? Okay. So causation issues in this particular cases, okay, can be clouded, okay, by other factors such as intervening health factors because of your body's reaction to certain drugs, for example, okay, or maybe because of your daily intake of the meal, your lifestyle also, okay. So it's cumulative effect. We don't know what's the real effect here. For example, in this case, XYZ and others, Ensuring Healthcare Limited. If you notice, can they use all the alphabet here? They don't want to reveal the name of the claimant or plaintiff lah. Okay, so the products involved here is the different brands of the oral contraceptive. This is the pill for family planning actually. Okay, the name is Famidine, Marvelin, okay, Minilet, and Meslin. And then there was allegation of side effects, okay, in the form of various types of cardiovascular injuries, such as deep vein thrombosis, DVT, pulmonary embolism, strokes, and others. But there's no concrete evidence to prove that. Okay, this is cumulative effect. You will, I mean, some people might suffer, some no, okay, or maybe because of the reaction, body reaction, combination with other drugs, okay, lifestyle, the meal. So the court held that there was no proof that the drug carrying excess risk of venous, venous thrombolism here, and the product therefore was not defective and was not the cause for the alleged side effects. Even side effects differ from one person to another. So how do you prove it? It's not that easy. Okay, to prove this is something which is defective. Okay, we want also to zoom to section 72 because we want to balance the case. Okay, I mean, producers, manufacturers, key importers, they are also I mean there are available defenses for them basically. So under section 72, it provides defenses for the producers. These are some of the defenses. Okay, for example, they can argue they have complied with legal requirements, and then argument also, producer did not supply the product. It was supplied by a manufacturer or by, I mean, any other person. Or another strong argument, the defect did not exist in the product at the relevant time. Okay, when it was being manufactured, no defect. Maybe during the transmission, during the delivery, okay, it developed defect, for example. Okay, or the component manufacturer's defense and also other general defenses are also available. Okay, to the producers can use defense of contributory negligence, okay, voluntary and injury. You all will learn under separate topic. For this topic, general defenses under thoughts one. Okay, let's have a look briefly at development risk defense here. Basically, it revolves around the state of science. I mean, this is the essence of the argument. Okay, which can be done, which can be made under this development risk defense. What's the meaning here? That the state of scientific and technical knowledge at that relevant time was not such that a producer of product of the same description as the product in question may reasonably be expected to discover the defects if it existed in his product while it was under his control. So in other words here, I mean that here whatever happened, they are not aware and it's not possible to discover, okay, by the current scientific and technical knowledge. So it could be very strong defense, okay, for the producer, even for the manufacturer. So this is similar to Denning-LJ decision in Roe and Minister of Health, in which it was decided, okay, the court decided, we must not look at the 1947 accident with 1954 spectacles because technology differs, okay, technologies are different, varies from one year to another, from one decade to another, okay, from the year 2000 compared to the year 2020, totally different altogether, okay. All right, and this argument, I mean, was relevant in this case, okay, the case that we discussed about contaminated blood. So A and others, and National Blood Authority and another. So one of the argument by defendants contended that, okay, they were unable to discover, okay, by means of accessible information, the defects in the blood product. I mean, it's not possible for them to discover to detect the blood was contaminated. But the court held that the defense is not applicable, was not applicable. Why? Existence of the generic defects was known or should have been known in the context of accessible information. There must be a way, okay, to detect basically. Okay, that's the court's reasoning. Okay, and the court said once the existence of the defect was known, okay, there was the risk that the defects materializing in any particular product, especially in the blood here, and it was immaterial, it's not relevant, okay, that the known risk was unavoidable in the particular product. So you know there could be risk of this contaminated blood here. So it's not relevant for you to argue, oh, we cannot avoid it. Okay, there must be a way to avoid it. Okay. So that's it. All right. So I stop share for a while. Okay, we finished the topic product liability. So I hope you have been able to benefit from the both parts of the recorded lecture. So that's all. Okay. Assalamualaikum warahmatullahi wabarakatuh.